We talk a lot about filing a lawsuit, but what does that really mean? What's the process? Hi, I'm David Henson, Managing Partner with HensonFuerst Attorneys. Once the decision is made to file suit in your automobile wreck or other personal injury case, our law firm leaps into action. The first major step is to research the applicable laws as they relate to the specific facts of your case. Then, we draft the lawsuit paperwork, which is called the complaint. After the complaint is filed at the courthouse, the court issues official notices of the lawsuit called summonses. These summonses and the complaint are sent to the sheriff, who delivers them to the defendants. This part of the process, from filing suit to serving the defendants, takes about 2 to 3 weeks to complete. Then, the defendants have 30 days to file an answer to the complaint, although this is usually extended to 60 days by the defendant's attorney. Once the answer is filed, the next step is called discovery, which is where each side gets to learn or discover all of the basic facts of the case. There are typically 2 parts of discovery: written and oral. Written discovery involves the exchange of written questions known as interrogatories. The defense lawyer will send us written questions regarding how the accident occurred, your previous medical history, and your injuries. We also send similar written interrogatories asking the other parties about how the accident happened, eyewitnesses, defenses they may have, and other types of questions. Each side has 30 days to answer those interrogatories, but again, this is usually extended to at least 60 days. After the written discovery, the next step is oral discovery, when lawyers get to ask questions in person. The lawyers for both sides gather with the plaintiff and defendants to take depositions, which are sworn statements and questions answered under oath and then typed into a transcript. We always advise our clients in detail about what to expect during a deposition so they're not taken by surprise during the questioning. Once depositions are completed, the next step is usually mediation, which is a court-ordered process to see if there's any way to avoid going to court. A specially trained mediator works with both sides to open lines of communications and facilitate settlement discussions with the hope that the parties can resolve the case on their own. The mediator doesn't make any binding decisions, but simply determines if there's any room for negotiations within the context of the lawsuit. A great number of cases settle at mediation. If mediation doesn't work for your case, then we proceed with the case by picking a trial date and conducting depositions of witnesses, your treating physicians, and any other people who might have relevant information about your case. Once we have all of that information, we can complete preparations to have your case heard in a trial before a judge and a jury. We tell clients to expect a 1.5 to 2 year period from the date they file suit until their case goes to trial. Although the attorneys at Henson Fuerst try to move each case as quickly as possible, unfortunately, the legal system in North Carolina is complicated, with intricate rules and requirements that keep cases moving as slow as molasses. As your attorneys, our job is to move your case as swiftly as possible while also building your case as strong as possible so that you stand the best chance of being fully compensated for your injuries. If you have additional questions about the lawsuit process or claims in general, go to our website at lawmed.com. This is David Henson with Henson Fuerst. If you have questions, we have answers.